Okay, I think it's time for a little recap, starting with this document. This is Christopher Howlett of E-Clause bringing forth a sort of I guess probably a short version, beginning with this mandate and how it led to the legislation that I have since put forth, which I'm sure everybody is still dying laughing over, which is the intended purpose, by the way. So that said, I'm going to dive right into this. This official mandate was granted September 18, 2018. Just so happened to be Stephen's birthday. So that's why I said at the time, happy birthday, Stephen. Dad was granted standing. Well, what was Dad granted standing to do? Basically, you are hereby commanded to that further proceedings as may be required be had in said cause in accordance with the ruling of this court and with the rules of procedure and laws of the state of Florida. Okay, follow the law and the rules of the court. I can handle that, right? And one of the main reasons that I can infer that he said pretty much just stick to the state of Florida, because at that time, remember, I had been utilizing the full faith and credit clause for Texas Article 1, Section 26. Perpetuities and monopolies are contrary to the genius of a free government. Yes, it is positive law, okay? But for the short version of where we were headed, to keep it consistent with Florida law, right? So it was kind of an understood but not formally on paper sort of a thing, if that makes any sense. That's why I said this is what happens when you deal with fractal calculus. There are certain things that are understood and certain things that can only be comprehended by people that have that knowledge. So this had to be, I had to remind the Sharia law court, you'll notice on 5/27 of 2019, that the higher court had already made its determination and granted the standing that it is me versus them, not them versus me, because they're an entity of fiction. They cannot act on behalf of Christina. They cannot act on behalf of anybody, hence the decusas challenge and removal de custo de movendo, which of course I'm going to get into. So, because that didn't come till later, as I said, this was the intended purpose. So let's go through it, starting with this mandate. You know, Sherwin set the Wayback Machine for September of 2018, as it were. So I had begun, right, oversight process in the legislature. Of course, many of you have seen that. Why? Because this was a dispute between the states, right? So hence the reason when you're looking at the motions, right, in the 116th Congress, okay, and the standing already being mandated, a justifiable motion number 24, right, was justified and appropriate. So getting back to the how we got to this Supreme Court order, that was this one here, dated March 14 of 2019, okay, where here's basically exactly what they said. This case is hereby dismissed. This court lacks jurisdiction to review an unelaborated decision from a district court of appeal, right, that is issued without opinion or an explanation, or that merely cites an authority that is not a case pending review in or reversed or quashed by this court. Okay, basically what I was telling them, they're basically telling me that they know and understand my comprehension that this started in Congress and my intention is to end it in Congress, right? So that said, we'll get into the foreign emoluments here in a little bit, which is one of the reasons why shutting this all down, again, justified and appropriate. No motion for rehearing or reinstatement will be entertained by the court. And that means from either them or me, which as far as I'm concerned is exactly what I wanted. So hence we'll get into 0 times 0 here shortly. So predicating this back to the brief, what was in the document, right? Well, again, this was my Supreme Court for the state of Florida, Christopher Hallett versus Department of Revenue, for emoluments of statutable plunder, Annals of America, Volume 2. And there's the violations, Title 18, subsections 241, 242, and 643. This is conspiracy to commit fraud. This is the commission of fraud. And this is the mismanagement of public funds, right? As a licensed practitioner, right, I can cite defective practices. As a mandatory reporter, my job on the clock, hence the joke on the clock, off the clock, comes to report these issues of unauthorized practice of law, and I'm standing my ground on this, right? I gave them 2 treatises, right? So it doesn't matter to me, right? You guys are smart. You'll pick one. We already know what the end result is. The end result is 0. So I said, okay, I found 2, right, from which we can proceed. Treatise on law and malicious prosecutions, hence this, Sharia law shite. And of course, treatise on false arrest and imprisonments. So the quote from the treatise on false arrest and imprisonments is forcefully to deprive a man of freedom to go wheresoever he may is clearly a trespass, period. False imprisonment was indeed one of the first trespasses recognized by the common law. I just walked in there and told them, this goes back to the common law. This has nothing to do with commerce. We're not even there yet. So knowing and understanding my comprehension of law and history, right, by citation of the language from the Declaration of Independence, which was at the time applicable. As you can see, a lot goes into my cover pages. These things aren't put together haphazardly. Okay. So for, we've talked about the great charters, right? The 3 charters. The 2 most applicable ones were Charter of Liberty, which is the Magna Carta, or Magna Charta, depending on your preferred pronunciation. And of course, the Farming Charter. So, language from the Declaration: in every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. Anybody who's ever read the Declaration knows exactly where that is. So, citing the judicial mandate, which I just covered, right, by and through the Honorable Justice J.P. Cohen. In other words, I knew what was going on. He knew that I knew what was going on. I wasn't going to make him admit it. He didn't cause the problem. Right? Only thing I needed him to do was grant standing, which he did, right? I said, okay, we're going to go on a little good faith here. I'm going to put my credentials on the line, right? This is a reciprocity agreement, right? I'm putting my credentials on the line, same as him, right? This is justified and appropriate, when only thing I was asking for was to mandate the standing. So I said it was kind of a no-brainer for the guy. So at the time I was the defendant, so the defendant by plea or exception becomes plaintiff, right? Which of course, again, why the standing was mandated as it was, right? Me versus them. Hence the dog Latin and my constant, ridicule of all of that. So these are the lawful principles on which I'm standing, hence the short list, right? So let's go down into this, and you know how I am. I'm going to speak it right out of the box. Who the hell am I, and what purpose do I have in this process or in this courtroom? And why am I bothering this guy instead of him out playing golf? Well, that's a justifiable question. So I walk in doing business as E-Clause LLC with full authority and standing pursuant to the attached judicial mandate, establishment of loss prevention practice, hence the corporation, and through the attached lawfully created corporation by and through the state of Florida Department of State to provide loss prevention services to the United States of America Corporation. Duties include, but are not limited to, right? What's the job description? I outlined 4 pretty clear criteria here. Hence, the malicious designs of men must be thwarted. That's pretty much the job description in the short run of this thing, isn't it? Investigations, knowing my job to do that was what I was looking for was integrity of legal and lawful process issues as unlawful emoluments, there they are, pyramid schemes, sham prosecutions, and of course, defective business practices, etc. Right? Things that are not, have no standing in law, since the Sharia garbage in Title IV, guess what? Foreign emoluments, you're out. Lawful and equal enforcement under the Constitution of the United States of America and the constitutions of the several states pursuant to Article 4, Section 2 of the United States Constitution. What did I just do right there? Said basically, dude, we're already in Washington. Don't worry about it, right? We're handling it, okay? It's got nothing to do with the state of Florida, only because there's a tangent involvement, because I happen to be based in the state of Florida. Advising the courts through this process in accordance with the established due process of law as I redress my grievances with my legislature. There it is. As written in the Constitution and paying due respect to Lady Justice in accordance with the Judiciary Act 1789. Tell them flat out who I am, what I'm doing, what my purpose is, and where I'm dealing with my grievance in the legislature. That's what it says. The IQ greater than the room temperature in Alaska problem comes later. So, grievances to be answered in this case by the court are pursuant to these fundamental principles or maxims of law, lawful process as follows. There they are. Justice comes before liberty. Justice is to be denied to no one. And here it is. Right and fraud never abide together. Period. I just cited fraud by lawful legal maxim. It has nothing to do with Christina. It has nothing to do with the state of Florida, and everything to do with the bad actors who did it. Moving on. Mind you, this is the preface, right? The introduction to the document. So you didn't have to go any farther. You knew where I was headed. How is it anything less than treason to continue to deny the people true justice under the law by not enforcing perjury statutes against government actors, right, in positions of emoluments, right? Knowing these 3 most fundamental principles and practices of law, the common law, right? Why I use maxims instead of case precedent whenever I can. I think it is safe to say that Judge Rentala far exceeded her scope and authority when she clearly subordinated perjury in her courtroom by not prosecuting the lies and relative other falsehoods presented against me at that time. Remember, we'd already verified all of that. So this crime can only be committed by a person in position of emolument. It's the reason you're seeing where this word, where the applicability and context comes in, meaning basically, and the power to commit the act, right? Subordination of perjury can only be committed by somebody on the clock. As such, cause for impeachment of her in her official capacity at the time of the offense is justified and appropriate. What did I just say right there? I'm affording due process, and I know what that process is. It's called impeachment, right? How many thousand million times have we said to you guys, follow the law and follow the due process, the process that's due them, right? So if you don't understand what on the clock means, right, how can you possibly articulate that you even have a total comprehension or even a substantive comprehension of what impeachment is and how many legs of impeachment there are? I mean, there's not just impeachment of the actor, there's impeachment of their case, right? Selective inclusion of and selective exclusion of relevant evidence and testimony, those emoluments violations under Brady, that's mentioned in here. How does the court reconcile, hold accountable The Florida Bar Association actors in using the Declaration of Independence as declared acts of tyranny like a checklist of things to do in these cases and not to perpetuate litigation, and those actions not constitute treason on the court. That's a question, right? Knowing and understanding that this started in Congress. This has nothing to do with Christina, by the way, because let's see, let's look at the case action. Who is this against? Oh, that's right. This entity in like kind, a corporation, right? Suing a corporation, doing business as E-Clause LLC. This is a corporation suing a corporation. This is what this looks like. How is Title IV et al. Of the Social Security Act, unlawful emoluments, anything but practicing barratry and extortion under the color of law? Knowing unlawful incarceration is the end result, as clearly established in this case pursuant to the cited unjust conviction law and the cited treatises. Ones I mentioned on the cover page, here they are. Malicious prosecution and false arrest and imprisonments. And here they are. There's those 10 principles of group decision making. I'm letting him know right out of the box. Oh, I know somebody assumed powers they didn't have. I don't need him to tell me that. It's right there, fundamentally, principally. Right? This is where I'm kicking their butts on principle. I was not present in any meeting saying that they could alter the fundamental law. I'm a registered voter. Ah, that means I have a voice. I have standing in law, and nobody consulted me. That means I can clearly claim somebody exercised powers they didn't have. Again, on the clock, right? So all members of the group are entitled to such notice of the time, place, and purpose of the meeting as will enable them to attend and participate. Failure to give such notice will invalidate actions taken at the meeting. Remember when we say insufficient service and insufficiency of process? There it is, right there. Proper notice of the meeting must be given to all members of the group, period. So if notice isn't given, guess what can't exist? There can't be a proper quorum if all the members aren't notified. They didn't provide service of the meeting. Oh, snap, right? And that's why I said I'm just going to have a little fun with this. Again, we're talking about, these are people that don't know me. They've never met me. They've never laid eyes on me. They don't know what I know, right? This is why you establish through your document, your court of record, right? As we've been properly teaching you for how long? Okay, so if a proper quorum can't exist, the rest of this falls apart. Fraud, right, becomes self-evident, right? Section 16, right? Yada, yada, yada. And what is the 10th principle is where I nailed it, right? Decision making, let's see. It is governed by any statutory or court-made law, including provisions of the constitutions and charters. Oh, nope, here it was, 9th principle, my bad. A person is entitled to protection of the courts from injury through injustice by a body making a group decision as in any other situation involving injury. Remember that injury by fellow servant on the clock? Is this making any more sense now? I hope. So be careful when you go and you say, oh, I'm not participating in the fraud and blah, blah, blah. You just cut your 6-pillar manly firmness foot off when you did that. Why? Because you can't claim a defense if you're not participating, right? So what is illegal ought not be entered under the pretext of legality. That's a pretty firm legal principle, lawful principle on which to stand, don't you think? The notice of appearance, I think you guys have pretty much read this. I've condensed it down to the four corners rule as I've gone along. I won't go through that. And of course, my corporate mission statement. What is this telling the judge, right? I've already given him my job description. What's my mission statement beyond my job description? In other words, I already know what I can and what I can't do. And I'm going to stand there and I'm going to let everybody and God to see it. And I don't give a damn. Right? Hence the, quite frankly, my dear, I don't give a damn. And of course, this element is not required by court rules, but I do it as a service, right? Letting them know that this document consists of 14,771 words on 54 pages, right? I didn't have to tell them that. That's a courtesy. Guess what? You extend a little courtesy, you're going to, extend good faith, you'll get good faith, right? They don't know what law, what history you know, because the only thing necessary for practice is a knowledge of law and a knowledge of history. So put a little bit of it in there if you happen to know some. It ain't going to kill you. So what's in this document? The petition, that's number one. Type page, the cover page. That's what I say. It's the cover page. So the preface, right? We just went through that. Notice of appearance went through that. Table of contents, that's where we are now. The appendix cover sheet, table of authorities. These are all things that come from the court's rules. We've been through this 1,000 times, right? So this is the construction of the document that comes from the court rules. So the judge said, follow along the rules of the court. I said, okay. So, again, I do things more consistent with the way we do them in the private sector, right? I'm not going to make the judge hunt for the cover page of the appendix, which is basically again, a table of contents. I'm going to put it with the table of contents where it goes. Make it easy on the guy or girls, whatever, right? I mean, depending on your thing. So again, what's the content? What's the tab number? And what page of the appendix is it on? Takes a little work to do this, but you know what? If you do the work, so I said the process of law is a heavy hardship. The law crowns or rewards the work, so do the work, right? You've heard me say this 1,070 times. Do the work. So I've extended the courtesy to tell him exactly where my year-end reporting is, right? Something he can go verify. Finder of fact, concluder of law. Okay, right? So I said, I can, whether it's good or whether it's bad for me, I'm the first one to say full disclosure, which, by the way, these are exculpatory. Either way, not presented in the process as was in the lower district court. But guess what? When they found out that there was exculpatory evidence, those Brady violations that existed that were not in the record here, now you can, this is what I said. All you got to do is get down through the cover page, right, and the table of contents, and you can pretty much see by now where the guy's, he knows somebody's in a heap of shit, basically, and it's got nothing to do with the court. So again, citing impeachments in the preface, I cited the Treatise of Impeachments, telling him, look, this is the process that is due this actor. I know it. Fundamentally, principally, here's the treatise. Bodies of law, learned treatises, right? You're going to claim and exercise something, claim and exercise your right. Where does it come from in law and why? Ineffective assistance of counsel journal. There's a journal on this, and there's a sanctions imposed by courts for abuse of judicial process. Guess what? There's a lot of information right here. And as far as Monell claims goes, that's the remittance process, right? We're not to that. Why? Because we're talking about debits and credits. This is all taking place through those 5 pillars of ill-gotten gains, right? So That's why I said, again, the proper process that has to go through the House side, right? You want to cite ill-gotten gains, mismanagement of government funds, you have to go to follow due process of law. Who controls the purse? Oh, that's right, the House of Representatives. It's got nothing to do with the court, does it? Right? So as I'm going through here, and just by citation and attachment of everything you see here, it's got nothing to do, of course, the executive orders, right? 13823 and 13818. So I'm paying attention, I'm acting in conjunction and in compliance with a lawful order issued to my corporation as a defense contractor by my commander-in-chief. Duh, right? So that's why I said these guys want to play Monopoly Corporation with loss prevention. Oh boy, that's why I said I'm having so much fun with these jackwagons. It's ignorant. But anyway, so without going into any more of the stuff that's in this document, you guys have been through this, I'm sure, 1,000 times. This is where I actually comprehensively explain in context what the negative nexus argument is in so much as each state, right? I believe it was, case argument Florida and case argument Ohio, right? So let's go to what happened in Ohio, right? We're going to use fractal calculus. Let's talk about that. So knowing and understanding that mathematics, like everything else, comes from the fundamental principles, maxims of law, right? -1 times -1 is 1, right? To me, this, anybody who studied basic algebra knows this one, I would certainly hope, but don't know if they've ever equated it to maxims of law before. That's why I said I'd never written an algorithm longhand at this point. This was just me being me, having a little fun. So what is this in context, right? The parties see, what the parties see, what the court sees. You have to explain it. So when I say, reading means reading, if you didn't read the document and you're asking me a question, I'll know you didn't read the document based on the question you're asking me, and here's how I know that. So the first step is to identify each factor in context of the current practices for closer examination, oversight, right? The first value of -1 is evidence presented or exculpatory evidence intentionally obscured from the eyes of the court. That would be those Brady violations, right? Under the premise of being used against the targeted parent in family court, or prosecutorial presumption of counsel unbeknownst to the court, as the court accepts these presentations in good faith as it has since the 1700s. The multiplication sign, X, establishes the elapsed time, right? Meaning the first factor of -1 cannot change. It is now a mathematical constant in context from now on. You can't unring a bell. That's the branding I've talked about, right? Where they brand you, right? They deny and disparage you, piss all over the 9th Amendment, right? You've heard Kirk and I say this a couple times. So false allegations of domestic violence in this case, hence the stepping on a Lego, but we'll get into that in a little bit. There's the case, right? As now permanently stapled to me until this court terminates it, so I may clearly or may clear my name and return to some semblance of normalcy in my professional life. I'm letting them know. Either you can do it or I'm going to do it. I really don't give a damn. Which brings us to the second factor of -1, being the conduct of the practitioner at the time of the presentation. This is not a mathematical constant in context, as we can clearly factor out the negative, leaving the value of +1, right? Or the practitioner as a mathematical constant, factoring out only his or her conduct, right? We are overseeing conduct because the positive or negative is the variable when you're talking about conduct. Was the conduct positive or negative? The fact Attorney Rich was clearly derelict in his duties to answer the first case of divorce, right? Here it was, leading to the second case, which was where most of my research applies. Remember that report? The one that was exculpatory? It's in this case. It's not in this case, right? Again, what the hell does this have to do with the state of Florida? Nothing, right? The obvious smear campaign against me, against this plaintiff, in basically this series barrage of SMU, in concert by the defendants and GAL Rockland Turner DePiro. There's the actor. Yeah, no, don't think I forgot about you, sweetheart. Yeah, just saying. As a mandatory reporter, challenging her position to accuse us, right? Those officers, yada, 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 from the declaration. Getting what I'm putting down here? Violations under Title 28, subsection 1927, the treatise on, or the sanctions against attorneys who abuse the judicial process, right? There's where you nail their ass. Can't claim good faith, right? Doan versus City of Independence. See ya. Actually, I think that's 85. I think I got a typo in there somewhere, but anyway, I digress. No, I have not forgotten her. Boy, you can tell it's been a while since I've written this, but as you can tell, she still clearly just irks me. Just the sound of her name is like nails on a chalkboard. Oh, I haven't forgotten her. I just had not figured out how to deal with her conduct until the Utah case. Ironically, it took the input of a mom stuck in this situation to find the answer. The credit for that work should go solely to her. It is what it is. Therefore, as the court-appointed ancillary related to cases, blah, 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 let's see, she too should be impeached, right? I should have said she also should be impeached. Terrible English there. In violation of Title 18, subsection 643, mismanagement of government funds. Where they got those bonds, that's unjust enrichments, right? As her part of this conspiracy to unjustly enrich herself is now clearly in the eyes of this court, and those orders be declared void. Guess what happened? That's exactly what happened. So I believe this is the last part of this that really is applicable here, and I'm going to move on to the next document. Unjust enrichment is an equitable doctrine that provides a remedy, right, where another party knowingly receives something of value to which he or she was not entitled, and the circumstances are such that it would be unjust for that person to retain the benefit. Ooh. Doesn't say advantage, doesn't say profit, doesn't say gain. It says benefit. That fourth pillar, that emolumentum. Oh, snap. A claim in unjust enrichment lies where the defendant's conduct is morally wrong. There's the cases. Hence, this is what Crystal found, right? To establish an unjust enrichment claim, right, the claimant must show that the defendant has knowingly received or obtained something of value for which the defendant, in equity and good conscience, should apply. Guess where those records are? Those records are in ACH, Automatic Clearinghouse. Guess who verified that? The House did. Hence the impeachment, right? See where this is going? This process is where my fiduciary license 4437079 becomes important. This credential qualifies me in the eyes of the court to articulate what constitutes conduct as bad conduct. I'm setting forth that I know what my advantage is, and I'm going to use it against another actor in a fake foreign emolument who has no standing. Again, what does this have to do with Christina and the kids? Not a damn thing. This is dad with his 6-pillar manly firmness foot. The fact that this practice is currently a monopoly is actually a threat to the integrity of the court. As we can now see and measure what is what in context of good faith presentation to the court to ensure the highest and best standards of practice be maintained at all times. Again, codes of ethics and all that stuff was on my test. And guess what's also available? That testing criteria being entered into initially when I was first licensed. Where would that have been? State of Ohio. Oh, snap, right? So I said, these bad actors, they thought they were going to get one over on the old man. They don't get up early enough in the morning to get one over on somebody who's forgotten more about law and fractal calculus than they'll ever know. So basically, here's what by oversight of the conduct, right? We've proven the negative. We've moved that second negative from here, the practitioner, right? And put it right there. That's what the equation looks like. The process that did that mathematically is right here. I am outside, not part of, that 4th and 5th pillar mechanism. I'm attached to my reciprocity agreement to the people of the state of Ohio, right? Can be found in either, can be verified by the 1st pillar, right? As it remains in the 2nd pillar, along with my oath of office, right? Duh. So to know a thing and to be bound to know it are regarded in law as equivalent. Moving on. This is why I said, right? I hadn't put in the cause of the thing causing as the cause of the effect here yet, but this is basically where I was alluding at that point, because I was just talking about on the equity scale, the ability to thwart inequities is necessary, right? Well, necessary, necessity overcomes law and laughs at the fetters of laws, getting into the legislation in the SMU Act, right? That's that principle on the basis of on the bottom of the legislation cover page. I continued from like right here, right? That's basically where I picked up in the legislation where I left off in my argument. Okay, so this is one of the reasons why getting back to zero is more beneficial than trying to litigate in the negative. But without knowing how to litigate in the negative, hence on the clock, right? How can you further articulate, maintain the integrity of the positive? You can't. To sit there and say that the negative doesn't exist, you're just denying yourself. You're denying reality. That's somebody who's, well, to quote a judge, somebody with an official with an IQ less than the room temperature in Alaska, which of course I cite in this document. But, and of course I go on here and I go through the statement of facts, right? And arising out of the Ohio case. So, again, if you guys want to, if this is posted, I'm going to stick it up here on Patreon for you guys, pretty much everything that's in this presentation. So this is why we got the standing order from the judge when the judge was like, oh, yes, guy knows exactly what the hell he's doing. And he's right. This has nothing to do with Florida or the Florida Supreme Court. Hence, no motion for a rehearing or reinstatement will be entertained, right? I'm telling him, look, I don't want to waste your time. You got better things to do, and so do I. So anyway, moving on. Now, this was the, remember that subsidiary motion? I had notified the court of that, right? By 5/27 of 2019 by electronic filing, right? So there it is. We've been through that 1,000 times. Remember, this was pre-impeachment, right? 5/27, 2019. Impeachment hadn't happened yet, right? So, and of course, don't laugh hysterically falling out of your chair when you read this, but because he's in a position of emolument, right? You have to, sometimes you have to choke on it, but it is what it is. Again, some of the crap we deal with on the clock, you know, have you ever seen Liar Liar? And he says, honorable, and he snickers. Yeah, well, you get, anyway, just moving on. Office of the President, right? By now I'd entered a parliamentary inquiry, right? What are those emoluments again, right? That was April 6th of 2019, right? What are emoluments beyond their dictionary definition, right? I think I said that up here in the, oh, wait a minute. That would have been back here. Or no. Right here. In order to rightly comprehend a thing, it is necessary to inquire into the names, for the right knowledge of things depends on their names. I put that as a maxim right next to the frickin' word in my appearance. All I had to do was, okay, he's here under Executive Order 13781 to do what? Find out what the hell this word is in context beyond its dictionary definition. I know what stipends are. I know what payroll is. I've written payroll once or twice. So I said, this is me having fun with foreign emoluments, Article 1, Section 9, Clause 8, right? The foreign emoluments clause that consequently doesn't have a definition in the dictionary. Oh, I wonder what that could be. That sounds a lot like a Brady violation to me. Moving on. So these are the, this was just an example, right? I had sent in, remember, the subsidiary 23, the main motion 24, right? And where I cited, right? Remember, see, also attached motions 23 and 24 to the Congress, right? There they are. So, you know, so that was 3 pieces of paper, and I also advised the court. I'm not hiding anything. So I said, we're going to play full disclosure here. They don't like it when I play full disclosure. It pisses them off a little bit. So, and of course, these idiots and these foreign emoluments being what they are on 531, they decide they're going to pull their bullshit again. Oh, yeah. No, you're not. So, no, you're not. Lawful notice of termination of employment and any contracts as a result thereof, right? There it is. I don't give a shit what the bar calls it. I'm not bound to bar stuff. I could care less what bar calls it. I'm here to provide notice of process and what my intent is. I'm going to put that in the title of the document. It is what it is. You're fired. Termination of employment. Get the hell out of here. The only person who can fire somebody is somebody who's on the clock. Oh, there you go. Come before you. Come before this court. Sui juris as corporate counsel. There I am. There it is. Verify that if you want. Practicing loss prevention. What the hell does that have to do with the bar? I'm standing against the bar. That bar is a foreign emolument. Get out. You're fired. And as the sole arbiter of the law in the form of this notice to submit lawful notification to this court. Lawful. It doesn't say anything about legal. This is lawful here. We're again, we know the difference between legal and lawful. Be so advised. Whoops. Yeah. Be so advised. Any and all 4th pillar and 5th pillar actors, processes, titles, entities, etc., is to be immediately prepared for submission through lawful termination of employment and contract processes previously established to be in compliance thereof. Ooh. So when we got the foreign emoluments have no standing in the Supreme Court, or I'm sorry, in the impeachment, see where this is going? So I'm already preparing these bad actors for this, right? Because this is what? This is notice of termination. I'm providing notice. Therefore, the attached proposed legislation will bring this county court back out of disrepute to be a lawful emolument. What did I just say right there? I recognize that these emoluments are in disrepute. They're infected by foreign emoluments. That crap out of here. You clean your house, I'll clean my house. I'm doing my job. I'm cleaning my house. Guess what the judges did? They went in and cleaned their damn house. So I said they're sick of this crap just as much as we are. So, and of course, as I do business, right, you know, I'm not going to stand there and whine and cry and bitch that somebody isn't disclosing something, and then I'm not going to do that. There it is. This is an attachment. Proposed legislation, SMU Act, aka File 13, right? And there's a memorandum of law, or I'm sorry, memorandum of legal authority. There it is. There it is. Practitioner's affidavit. Everybody knows what an affidavit is, I would certainly hope by now, right? So I said, you guys want to play license? I'll play license with you, and you're not going to like the end result when I'm done, right? Because I know what zero is. I know what SMU is. So, you know, again, right here, tell them flat out, Supreme Court ruling, there can be no sanction or penalty imposed upon one because of this exercise of constitutional rights, period. So when I say those rights to work, those constitutionally protected ones, I'm in law, buddy. I'm on the clock. Don't you screw with me, right? So this is what I said. These bad actors don't even know the difference between on the clock and off the clock. Hence the, you know, I had to be very, very careful in the submission of a writ of supervisory control. And what is that writ? Zoom in on this so you guys can read it. A writ issued to correct an erroneous ruling made by a lower court when either no right to appeal, where there is no right to appeal, or when an appeal cannot provide adequate relief and the ruling will result in gross injustice. Again, this started in Congress. I'm going to end it in Congress. This doesn't have a damn thing to do with a court, because as it is right now, the court is in disrepute under Title IV and Sharia law. It's the crime scene. Judge knows it. I know it. He knows that I know it. It's all that matters. Here's the actions, right? Another motion that I sent to Lindsey Graham. The first one was to Nadler. This one was to Lindsey Graham, basically saying the same thing, pretty much. I've also CC'd the Ohio and the Florida houses of Congress. I let him know, Lindsey Graham, that this also went to the Ohio and the Florida legislatures. Guess who else knew that? The judge saw that I was following due process just by looking who was carbon copied. So I said I made this so easy for these guys, it was stupid, because they knew damn well I knew what I was doing. So when I said, what do you need from me? And he just says, just keep doing what you're doing. So now here's the difference. Remember, Congress is assembled, was dominated primarily by the merchants during the First Continental Congress, right? Who was this guy doing this business? So I said, you want to play Monopoly Corporation with me? No, you don't. So, as I said before, necessity overcomes law and laughs at the fetters of laws. I'm laughing in their face. I know who they are and I know what they're pulling, right? Hence my Space Force emolument. Oh, God. There are days that this is too much fun to be called work. But anyway, moving on. So, this is where things start to get a little hairy here locally, right? Remember, 527. I had filed a writ of replevin into the judicial branch, right? And I'd also filed a copy of this. I dropped a copy of this off when I filed with the heading on it was Marion County Legislature, right? This copy went to the court And there's a different version of this that went into the state legislature, which I'm going to show you guys in just a minute. But it's basically the same document. And one of the reasons why I'm showing these ones first is because, number one, this establishes the timeline, right? So this one was filed, the writ of replevin was filed on 5/27 of 19. And the, this was a notice of appeal. That's right. Insufficiency of service and insufficiency of due process, right? Hence that we've covered that in the 10 principles of group decision making back in the Supreme Court brief. So that's why I said I just laid the smackdown on these. Basically, the short version is the appellate court agreed with me. By now, all this shit is moot because I've already made my point, right? Already proven the negative and all of that stuff. So again, full disclosure. So I say I'm kind of a jerk about this, right? I hit him with every bit of this, all of it, right? So the conduct in context of no jurisdiction, right, KNOW, is indicative of attempting to further question the integrity of the Florida State Supreme Court standing order by current actions indicating these types of questions. Can I buy a vowel to get more money in this case? Or can I phone a friend to get more money in this case? Or maybe ask the audience to get more money in this case? So, as you can see, I was trying to be politically correct, but but I suck at it. So, anyway, I digress. So let me go back into I'm going to stop sharing right there for just a second, and I'm going to pull up the Marion County version of this because it was applicable. I put out a copy of this a while back, and somebody had requested that I put it out in in its Microsoft Word format. So I'm going to do that on Patreon as well once I get done uploading this video to YouTube. So this is in the office of county commissioners in Fort Marion County, Florida, right? They don't have an electronic filing process. You have to hand deliver service on these, right? So this is a writ of deceit, right? This is where you go in the legislature and you throw the truck at them, right? You pick up every book, every fucking lawful principle you can wrap your fingers around, and you just start beating the snot out of them with lawful arguments. Again, this has nothing to do with the illegality of a contract. This is going in there and beating the snot out of these bad actors with the law and due process of law, the right way, right? And the best way to do that is not only what it is, where can they verify this if they're in a position of emolument on the clock, right? If you're going to bitch that somebody cannot claim good faith when they're on the clock, and you're not going to extend that good faith either on or off the clock. You see where I'm going with this? So you got to kind of know what on the clock means. So on the clock, there's that lawful principle, and I even highlighted it for them. The person whose legal position is an issue, right? That is a deception, right? This is a writ available to a party who was deceived and damaged by someone acting in the party's name. That would have been that Florida Department of Revenue acting on Christina's behalf. Guess what? they can't do that, period. So the writ to remove them was de custodiam avendo. Verify that. See where this works and why this works? So, and I don't care if it's a guardian ad litem or somebody else claiming that, oh, I'm here to protect your safety. Get the hell out of here, you jackwagon. So, again, knowing and understanding that people in the legislature, they're not dealing with courts every day, right? You have to provide detailed instructions. What does the letter of the law say? Instruct your representatives. Hence the problem that we had in Nate's case, where remember where he said, I felt sorry for this poor guy because he pretty much said to Nate right to his face, he goes, I get you've got a problem. I just don't understand it. You guys are way over my head. That you know what? As far as I'm concerned, I'm gonna extend that guy some. He's kudos to him, right? I mean, to be doing something for that long. He'd been, I think he said 11 years at the time, and we were way over his head. That's a man of integrity, and in anybody's book, I don't care if you're on the clock or if you're off the clock. So, kudo to Nate's representative, for the 1000th time, right? For having the balls to admit that, right? Good for you, dude. Good for you. So, again, this is the not pro se as alleged in this fraudulent Sharia law sham process by this hearing officer who has, as evidenced in the record, continually attempted to reduce this plaintiff's lawful standing in society through his odious claims, hence the corporate dog Latin, right? And of course, too much subtlety in law is condemned. This is when, when you start exercising that manly firmness foot, right? You got to kind of, yeah, I understand that. I know it by principle. I'm just pissed. So deal with it. You want to get rid of, you want me to not be pissed? Go deal with this bad actor who is standing in this fake emolument, right? Who's guilty of unauthorized practice of shit made up. So, let's see, or may have something on the, here we go. He may have the rest of these judges fooled with his shit made up, or may have something on them. In other words, I don't know, and I really don't care, keeping them from performing their fiduciary duty to the Constitution. But make no mistake, I see right through him for whom and what he is, as well as where he stands in the 5th pillar of Sharia law. Don't tell me I don't know the law, you dumb shit. So, like him, I've spent my life studying my enemies, so I know one when I see one. If he's not shaking in his Sharia shoes yet, he will be when I see him hanging in the town square for treason according to the letter of the law. Where's the law? Title 18, subsection 2381. Why? The crime of treason exceeds all other crimes in punishment. Period. That's a maxim of law. So again, you want to make a lawful argument? Cite the law and cite your lawful standing to make the argument. Right? This is alleged, by the way, this was not in a court. This was in the legislature. You see what I'm, see where I'm putting down here? So, and again, there's same memorandum of law, legal authority, points of authority, practitioner's affidavit, who I am, what my emoluments are, what my experience is, right? You got to tell these guys this stuff, right? The supervisory control, right? I also put a, change the cover, right? To go into the legislative body, because I already advised the court I was taking control of that Sharia sham shit with my 6-pillar manly firmness foot, telling them, no, you are not going to screw with my ex-wife. That would be an error. Nice try. She can get as pissed at me as she wants. Because why? Because I allow it. That allowance extends no further than that. So she wants to get mad at me. Chances are I may even deserve it. So moving on. Here's how I hit him with this. I posted this out there. I think it was Facebook the last couple of days. So let me start up here. As for where I receive my political authority and cause of action is concerned, see Article 1, Section 1 of the Florida Constitution. Also be advised that I am currently working with Congress in an effort to course correct this epic fail that is Title 4 as emoluments violations, Article 1, Section 9, Clause 8 of the United States Constitution. Look, I'm telling them who I am and what I'm doing, right? You leave me alone, I leave you alone. See how easy this is? I will begin by directing your attention to the 5-pillar construction of this title, A through E. I will now point out the obvious conflict of this title not being Republican in character or form. I will further clarify it for you in breaking down each of the 5 pillars being consistent with this foreign ideology as follows. Right? First pillar, right? Political acts of domestic violence against women and children, hence the Adoption and Safe Families Act, right? So the Violence Against Women Act and Adoption and Safe Families Act. Don't tell me I don't know the law. Don't tell me I don't know a malicious design when I see one. Bullshit. And let's see here. There was one section. I think it was. Where was it? Here it was. What person in their right mind could contemplate the allegations levied against myself, my 3-year-old son, and my 5-year-old daughter as attempting to overthrow the government of the United States in this case? Do you have any notion how absurd that is when you actually read the language of the Constitution? Seriously, did someone step on a Lego, or did my 5-year-old duct tape to someone and someone to a chair and force them to watch countless hours of SpongeBob SquarePants? I mean, come on. So I say, you want to make these idiots look like the idiots they are? Just walk up there and punch them in the face with a dumb question. So, it is what it is. Again, 9th principle of group decision making, telling them, even if you don't know it, I certainly do know it. So, we having an IQ problem here or what? So anyway, I just thought I'd have fun going through some of my old documents with you guys. Where was it? Yeah. We in the private sector as well readily suffer the ill effects of ideas that often sound better in our heads while enduring the rigorous research and development phases of any project or idea. Yeah. We as well often find ourselves in policy review meetings scratching our collective heads, pondering questions like, what the hell were we thinking? And who will be getting fired as a result, or who will be getting fired for the waste of this waste of time and resources? And of course, my job to hear behind closed doors was, who the hell was responsible for this colossal clusterfuck? Fire everyone. So don't think this problem is unique to public sector politics. Right? It is what it is. Private sector politics and public sector politics, it's the same crap. It is what it is. So you think you're going to stand there and bark at me and I'm going to be, what, intimidated by that? Yeah. Yeah. I've argued and litigated with bigger and uglier than you, trust me. So anyway, let's see. Fortunately for the public sector, our same 10 principle. Okay, yeah, this was in the SMU legislation, so I'm not going to go over that. But, again, it was sometimes you just got to repeat yourself, whether you like it or whether you don't. So anyway, I'm going to post this video on YouTube, make all these documents available on Patreon. So I said this was just a review, right? Pretty much to kind of, clear out some of my documents and answer some questions, because we're going to be posting a lot of this stuff out there, and you may see some of these things appear in multiple posts in the Patreon site, right? So now, again, because this is a non-integrated system, right? Meaning, writ of supervisory control may be applicable for one of you, whereas a writ of replevin may be applicable for somebody else, right? So that's what I mean when I say it's non-integrated. Each document is going to be consistent with each person, each in accordance with their own, their own right. And depending on who trespassed that right and what your right, moving forward, as we define clearly in context, because remember, we got to have a reason to do a research project, right? You're not just going to say, I'm here doing a research project. Well, yeah, what is it you're researching, right? Can you articulate that? think you probably should be able, you better be able to do that, because guess what? Somebody's going to be asking you, right? Somewhere along the line. So what is it we're researching? Potential emoluments violations under Brady by lack of a definition in the dictionary of Article 1, Section 9, Clause 8. Remember, we got Article 1, Section 6, Clause 2 nailed down. Where's the foreign emoluments clause? Why don't we have a definition there? Right? I think that is a defense problem, right? Department of Defense, right? Not going to leave the people defenseless, subject to prosecution by foreign emoluments. Get the hell out of here, right? And of course, me being me, what would those markets look like? Oh, well, and again, you know, you guys have watched the video. I'm certainly hoping by now you've watched the video, so you know what the difference is between a lawful postal road, right, that allows for, you know, what for what, and a reciprocity, mutual concession of advantages, the return on your investment. It is what it is. This is the minimum standard. You can't drop below that, and you certainly can't usurp the law. So quit doing it. So anyway, moving on. This is, I'm hoping you guys are enjoying this work at least as much as I am in review. So when we're getting back to, and we're looking to be able to better articulate, right, in the context of what this bad rascal here is, right? We keep saying, why is zero an improvement? Well, once you get out from below the line and you get to zero, trust me, you start to see how much an improvement zero can be. But again, knowing what they're doing on the clock, that's quadrant 4. They're doing this crap, right? What does any of this have to do with Christina or the kids? This is part where I cue that Jeopardy music, but I'd probably get a freaking one of them their strikes, whatever they call them. Anyway, moving on. And of course, it was constructed by these actors down here, right? Fourth pillar working in conjunction with the fifth pillar. I don't give a damn who, and I don't care what their beef is with each other. You want to kill each other, have at it. That's got nothing to do with us up here in the private, right? Going to work every day. So you want to kick the crap out of yourselves down here in the public sector, dude, have at it. You guys want to participate in this and kicking the crap out of these guys, getting them the hell out of here? Come on in. The swamp is fine. So this is what an impact assessment looks like, and why I know and understand this as fundamentally and principally as I do, as we've explained through many of the PowerPoints of the construction of this document. So now that we've gone through some of the timeline, right, and how I got to zero, right, hence resolution and resolutions and tort claims, that information is going to be forthcoming. But now that we've gotten to zero, right, now we can proceed. So on that note, I'm going to stop this recording, stick this out on YouTube, and get these documents posted on a Patreon for you guys. Again, I want to thank everybody for, jumping in. Everybody's done so, amazing work. I mean, there's just no way, I could ever articulate the incredible nature of how many people have picked up this book and picked up that torch of liberty and started to go after, right, these bad actions that happened in the legislature while the rest of us were out dealing with life, doing work, raising our kids, getting smacked in the head with whatever, whether you deserved it or whether you didn't deserve it. But either way, Some cases, I'll be the first to admit I probably deserve some of it. So, but anyway, again, get a copy of the book. Don't have a definitive release date. Only thing I do know is I keep hearing rumors of sometime November of 2020 we'll get the new book, but whether it will contain the Charters of Liberty and, you know, farming and the rest of all that, again, we'll have to wait and see what happens when it comes out. Maybe that's one of the things they're waiting on. Who knows? Maybe we're going to see definitions of foreign emoluments and what those are moving forward. Because once that happens, guess what? I'm going back to my office. So on that note, much love, everybody. I'll see you tomorrow night for Monday Night Law.